for our online class sessions in the week, but for everything else, written work and um, consultations, I'm available again from Friday, the 13th of November. Okay, so I'm on for class this coming Monday and Tuesday, but for any other consultations for the submission of written work, whatever, I'm only available from Friday, the 13th of November. From the For the rest of the week, I'm caught up in some work commitments. Okay. So, with that, I'd like to start our, our revision session um, of law of persons. Okay, so before I start, are there any questions for me? Any questions? Any questions? Okay, so quickly, we're going to go to page 21 in the course reader. We're going to start there. So we have to go through. So have we gone to unit 19 yet? What is unit 19 about? Let me see quickly. Hold on. I'll have to go to unit 19 now. Immense. Oh, yes. Thank you for reminding me. Okay. Let's finish emancipation quickly. My apologies, students. Okay, let's go to unit 19. Yeah, go to unit 19. Sorry, buddies. Ek het skoon vergeet daarvan. Just give me a minute. I'm just browsing through my iPad to get to unit 19. And then I need to access the textbook as well to go to emancipation. Then we take it from there. No? Whoa. Okay, I'm at unit 19. Okay, unit 19, termination of minority. And the first aspect we're going to look at is emancipation. Paris, let me finish 19 first, then we look at 17 and 18. Hmm? So let me finish 19 quickly. Let me just access the textbook as well. Give me a second. Uh, contents. So Emancipation 6.4, 6.5. Okay. Let me just go to the textbook as well. I have everything electronic, so I just need to access it quickly. 6.5. Okay, here we go. Students, apologies, I was just on the line with Adele Blacker from UNISA, and she's been experiencing some technical difficulties. That's why she couldn't speak to us. So we can continue now. Okay, so students, let's look at what emancipation deals with. Okay, so basically, Okay, a minor, okay, this is a person under the age of 18 years old, students. Okay, a minor is emancipated, okay, if his or her guardian grants the freedom, okay, to independently enter into contracts. Okay, so this is where the guardian or parent grants the minor the freedom to independently enter into contracts. Okay, and students, this happens, for example, where the minor participates in a commercial enterprise as an economically independent person. Okay, so meaning, okay, this means emancipation can be compared to a situation. Okay, this means that emancipation can be compared to a situation where the minor, very, very importantly, and please take note of this, okay? Very, very importantly, where the minor performs a valid juristic act with the assistance of his or her guardian, okay? In the latter instance, the guardian consents to a specific act, okay? But in the case of emancipation, the guardian consents to a range of juristic acts falling within a particular sphere, okay? And a particular sphere can be, for instance, an economic enterprise, okay? So, whenever such consent is given, the minor incurs liability like a major. Okay? The minor incurs liability like the major. So, in terms of process, students, in terms of process, either parent may emancipate the child provided the parent has guardianship of the child. Okay, so for 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 this action, students, okay, in terms of our section 18 rights, in terms of the Children's Act, yeah, guardianship is very important, and the person granting emancipation must have guardianship over the child. Okay, so whether minor is emancipated if one guardian emancipates the minor while the other refuses to allow the minor to be emancipated, that situation is still unclear in our law. Okay, so if the minor has no parents, students, if the minor has no parents, the legal guardian may emancipate the minor. Okay, so also you must be mindful that emancipation can be effected by express or implied consent. Okay, consent must be express or implied. meaning, here, mere carelessness on the part of the guardian does not result in the minor's emancipation. Okay? And also, whether or not the minor has been emancipated is a question of fact. Okay? So, a factual inquiry must be done. Okay? And here the court must decide if it becomes a legal question. The court must decide upon considering all circumstances of the case. Okay. Um, we look at some factors. The minor lives on his or her own, manages his or her own business, or mere factual details together with other factors such as age, the relationship between the minor and the guardian, the nature of the minor's occupation, and the length of time which the occupation has been carried on, help to establish whether emancipation has in fact taken place or not. Okay, so those are all the factors the court look at. The court doesn't look at them in isolation. Okay, and then also, if the minor lives with his or her guardian rather than on his own, okay, stronger evidence will be required to prove emancipation. If we look at onus students, okay, the onus on proving emancipation rests on the person who alleges that it has taken place. Okay, so the onus of proof on whether emancipation has taken place or not rests on the party alleging it. Okay. Okay. It is also unclear in our law, students. It is also unclear in our law on whether a guardian who emancipated a minor may later revoke this emancipation. And all we have regarding this is obiter dicta. Now, you know that obiter dicta is a secondary source of law. So regarded as a secondary source of law, meaning that it can never be authoritative or binding or set legal precedent, okay? But it's only a source of persuasive value, okay? And obiter dicta, if you translate it from Latin to English, it's remarks made in passing by the presiding officer while handing down judgment. And in Cohen versus Seitner and Landman versus Mini support this view that emancipation is irrevocable. Okay? Okay. So, um, lastly, students, it also tells us that the question of the effect of emancipation on the minor's capacity to act has not been decided authoritatively. So There is no precedent or case law regarding this question, and also the issue is whether emancipation only applies to transactions, okay, or whether it may act beyond the scope of the business, okay. Some cases are, are of the view that emancipation gives the minor capacity to act in respect of all contracts, except that the minor may not alienate or encumber immovable property or marry without his or her guardian's consent. Okay. In other cases, it was held that the minor is emancipated only with regards to contracts to a particular business. Okay. So you must be mindful of all of this. Okay. And also, let's look at the common law position. So, at common law, tacit emancipation terminated minority, while general authority was no more than advance consent to enter into transactions of a certain kind. Okay, so please be mindful of that distinction. Okay, at common law, tacit emancipation terminated minority, while in terms of general authority, it was no more than an advance consent to enter into transactions of a certain kind. Okay. Um, very, very importantly, also students, um, the courts seem to assume that an emancipated minor has locus standi. Okay. Um, if you look at the if you look at what he said, okay, if you look at the commentary, it says a guardian who consents to a minor entering into a specific individual transaction does not automatically also consent to a minor engaging in litigation regarding that transaction. It therefore seems inaccurate to assume that the minor who has been emancipated automatically has locus standi in judicio in respect of all matters falling within the sphere of um, transactions related to his or her emancipation. Okay. Any questions for me, students? Any questions on emancipation? Okay. That is, what does common law mean by advance consent? Okay. Let's go back to that, Paris. Okay. It tells us, okay, If we go to the general view, okay, I'm saying tacit consent, okay, implies at common law that the um, minor is emancipated, okay, but generally, okay, generally the purpose of emancipation is for the minor to enter into valid juristic acts in terms of a certain sphere only. Okay. And as I said, in terms of an economic activity. Okay. That is the general view of emancipation. Okay. But there's also a view that once emancipated, it provides blanket consent, okay, or advance consent for the minor to enter into various juristic acts, okay, and that's where there's uncertainty with regard to the legal position, okay, because let me give you an example. Okay, I'm 16 years old and you are my father. Okay, and I now operate a successful car wash business where I employ 25 people. Okay, I have a successful car wash business. It started as a hobby, but now it's become a fully fledged business. It's become an economic activity, and I now, as a 16-year-old, need to make certain business decisions, and I cannot run to my parent or guardian every time that I need to enter into a juristic act. What do I, as minor, now do? I get permission from my parents to emancipate me with regard to the operation of the car wash business. So I'm emancipated now and I enter into a lease contract because I lease the premises where I wash the cars from with my 25 employees. I enter into employment contracts. I open a business banking account, all of that. Okay. Do you agree that in terms of the business activity I'm involved with, which is a car wash, um, and in terms of emancipation, I am now an emancipated minor and I act independently and I now enter into valid juristic acts. Are you with me thus far? Okay. Now, Now, some may view that in terms of what emancipation is about, okay? In terms of what emancipation is about, if one looks at the definition thereof, okay, the freedom to act independently, okay, to enter into certain contracts, okay. For example, where the miner participates in a commercial enterprise as an economically independent person. This is now where I explain generally what emancipation is about. Okay, so as I'm earning money, I now tell my guardian or my parents, listen, I'm earning enough money. My the space in the house is getting too small for me. I'm going to rent my own apartment where I have more space, where I can set up my computers and where I can have business meetings, whatever. I'm moving out and I'm buying a car on the business's name, and I'm going to get someone to drive me around and all of that. I'm moving out now, blah, 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 blah. Okay. I am turning 17 years old and I start going to parties and people are just impressed with me. And then there's someone I fall in love with. And what do? We decide to get married. Okay. Now I tell my parents, listen, I'm getting married. Okay. Um, and I in I have so much money now. I'm going to buy immovable property as well. This flat that I'm renting, I made an offer to purchase, and now I'm going to buy this flat. Okay, so what have I explained to you? Two juristic acts. Okay, the one of getting married and the one of buying or purchasing immovable property. Okay, question to you. Those two acts, okay, do they form part of the scope that has given to me in terms of a commercial enterprise and acting as an economically independent person? Yes or no? Yes or no? No, they don't. Okay. Paris says no, they don't. Angela says no, they don't. But what will my argument be as the minor? My argument will be is in terms of emancipation, you have given me blanket consent to enter into various juristic acts. Okay. So this is where you need to draw the distinction between a blanket consent and what emancipation is generally about. Okay, and once you 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 determine the facts of the problem, you can then argue whether the consent granted for or whether juristic acts performed in terms of of the guise of emancipation, whether it falls within the ambit of that, yes or no. But also be mindful that as lawyers, and especially when it comes to an aspect such as emancipation, and where there is no clear authority with regard to it, but only views, remember, views and obiter dicta cannot be presumed as authoritative. Okay, so in the absence of clear authority, okay, these issues still needs to be decided by court. Okay. Okay, Angela, generally there's no thing such as blanket emancipation. Okay, there's no thing such as blanket emancipation. So in my view, okay, in my view, I agree with the stance. Okay, and it's also a view because it hasn't been tested in court. But in my view, I agree also that emancipation does not absolutely end minority. Okay? Because I agree with the stance or the view that um, the, the purpose of emancipation is to grant an emancipated person or emancipated minor the freedom to enter into contracts, but these are specific contracts related to the reason for emancipation. Okay, so when you are given a problem question with regard to emancipation, you must always, when you answer the question, you must go back to see why emancipation was granted in the first place. No, Perez. Okay? The consent you're talking about relates to emancipation because here these acts will fall in a specific sphere. Okay? So you are what you are explaining to me now here is general emancipation. Okay? Where the minor, sorry, where the guardian grants consent for emancipation for the minor to carry out a range of juristic acts within a specific sphere. Okay, and then an example of that specific sphere can be an independent economic activity. Okay, so Paris, there you just nicely explained to me what general emancipation is. Okay? Okay. Any questions? Does someone else need clarity on the aspect of emancipation. Okay, I just want to go to the following. Um, okay, um, I just want to see something quickly. Okay, so if you you go to the part where I said our courts seem to assume that an emancipated minor has locus standi in judicial. Okay, but the view is that that locus standi in judicial only is in respect of those matters which fall within the sphere of the transactions in which the minor was emancipated for. Okay? Only in terms of the sphere in which the minor was emancipated for. Okay? Okay? Yeah, I want us to look at familiarize yourself with the following case. The question whether emancipation confers locus standi in judicio on the minor came before the court in Ahmed versus Kuvadia, okay, in 1944, and Sessing versus Minister of Police in 1978. Okay, on these two cases, it was unfortunately unnecessary for the courts to decide on the question. Okay, so although these matters were before court, okay, it was not legally tested and it wasn't necessary for the court to decide on this action. So, um, the court seemed to hold the view that the minor has locus standi in judicio only in respect of those matters that the minor um, received emancipation for, but it has not been validly tested in our courts. Okay, and this is in terms of the Ahmed versus Kuvadia case. Um, Ahmed versus Kuvadia and Sessing versus Minister of Police. So Ahmed versus Kuvadia was a 1944 case in the Transvaal Provincial Division, and Sessing versus Minister of Police was a 1978 case in the Witwatersrand Provincial Division. Okay. Any other questions? Um, Perez and Manny. Which edition of Eton are you using? Which edition of Eton are you using? Are you using the 6th edition? Just confirm with me quickly. Which edition? Manny and Perez, I see you guys are quoting from the textbook. Perez, edition number 5. Perez and Manny, do you have electronic versions of those books? Manny, can you send me an electronic version to my email, or do you have it on WhatsApp? Manny, can you email it to me? Okay, Perez, you wanted me to look at other modules as other learning units as well. Um, 17 and 18, you said. Okay, let's see what 17 and 18 is about. Oh, 18, marriage. And 17, um, okay, let's go to this quickly. This is easy things, okay? Page 119, students, page 119 in the course book. That is, what do you need to clarify? Angela, do you want to say something? Angela? No. Paris, what do you need to clarify? Let me see what Paris's question is. So advance consent can refer to blanket consent. Yes. Okay. Advance consent can refer to blanket consent. Yes. Okay. Where consent is granted to to engage in various juristic acts, okay, and those juristic acts does not necessarily have to do with one aspect related to emancipation, okay. So let's go to paragraph 17, where we deal with the minor's capacity to enter into other types of agreements. Okay, I'm again just going to um, capacity to enter into other agreements. Okay. Thank you, Angelina. Okay. So, students, very, very importantly, the mind's capacity to make a will and witness a will. Okay. So, once a minor reaches the age of 14 years old, the minor may witness a will. Okay. Once the minor reaches the age of 14 years old, the minor may witness a will. The minor who is 16 years old, students, 16 years or older, may make his or her own will and in it dispose of his or her property as he or she pleases. Okay? So, when the minor reaches the age of 14 years old, okay, let's look at the the requirements for a minor to marry. Okay, so let's first look at civil marriages. So, firstly, students, a minor may enter into a civil marriage if he or she has the necessary consent. Okay, so all the guardians of the minor, this is both of them. Someone has a question whose mic is switched off. Okay, thanks, Angela. I see it will still upload. Um, so, students, all the guardians of the minor must consent to the marriage unless the court orders otherwise. Okay, so if the minor boy is below the age of 18 years old, okay, or a girl below the age of 15 years old, okay, he or she must obtain the consent of the minister of Home Affairs in addition to obtaining the consent of his or her guardians. Okay, that is if a minor boy below the age of 18 or a girl below the age of 15. Okay, then the minister's power, students, very importantly, before I go to the age of 12 and 15, okay? Children below the age of puberty cannot enter into a valid civil marriage. Okay, so um, the minister's power to grant consent applies only to civil marriages of girls between the ages of 12 and 15 and boys between the ages of 14 and 18 years old. Okay, if a guardian is absent, mentally ill, or in any other way incompetent to consent to a minor's civil marriage, okay, or the minor can, for any good reason, not obtain the consent of his or her guardian, the presiding officer in the children's court may grant such consent. Okay, the presiding officer must also determine whether it is in the minor's interest to enter into an antenuptial contract or not. Okay, okay. A minor who has previously entered into a valid civil marriage or a customary marriage and whose marriage has been dissolved by death or divorce may enter into another marriage without having to attain consent. Okay? Then a minor wants to enter into a customary marriage needs the consent of both guardians. If such consent cannot be obtained, the minor may ask the presiding officer of the children's court to consent to such a marriage. Okay, so very, very importantly, students, when it comes to a civil union, okay, the civil union restricts civil unions of people who have already who have not reached the age of 18 years old, meaning a minor cannot enter into a civil union even if assisted by a guardian. Okay, so in order to be a party to a civil union, you must be 18 years or older. You must have attained the age of majority. Okay? Okay? If one looks at the consequences of entering into a civil marriage without the necessary consent. Okay?
Hi, advocate.
Yes. Is this
Hello, can you hear me? It's
Angelina?
Angela here.
Yes. How are
Yes.
you?
Okay, good things yourself, sir.
Good, good. What is your question?
So I was going through one of the question papers, and I'm not sure if you answered this, but in the last statement that you just made, I just need some clarity.
Mm,
Um, the question says, Ntabiseng is 16 years old. She wants to conclude a civil union with Tabiso, who is 19 years old. Tabiseng's parents have agreed to assist her to conclude the civil union. Explain whether Tabiseng and Tabiso may conclude a valid civil union.
it will not
So, because
be.
Tabiseng's. Mhm.
Are you saying, in terms of the question, one of the guardians consented to the civil union?
Yes.
Okay, it cannot be a valid civil union because, in terms of the definition of the civil union, or what the act requires, is that if you look at the definition, a civil union is a voluntary union between two parties who are 18 years and older. Okay, so
Okay.
you must be a major. It's peremptory, it's legislated. You must be a major, 18 years and older, to be a party to a civil union.
Okay. Thank you.
Okay, you got that?
Yes, thank you.
Okay, so students, let's look at the consequences of entering into a civil marriage without the necessary consent. Okay. Um, okay. The patrimonial consequences of a customary marriage. Okay. Where a minor enters without the prerequisite consent is governed by Section 24(1) of the Matrimonial Property Act if the customary marriage is set aside. Consequently, the court may make any order with regard to the division of the matrimonial property it deems just. Okay? It is unclear what patrimonial consequences if an unassisted minor to a customary marriage is not set aside. Okay, students, let's look at medical treatment, operations, HIV tests, and contraceptives. Quickly, I think you can do this on your own. Okay, you can do the minor's capacity to consent to medical treatment and operations on your own. Okay, and then let's jump to 17.7, which is very important. You can make NB that next to that, the minus capacity to litigate. Okay, so students, the general view is, or the general rule is that the minor has limited locus standi in judicio in civil proceedings, meaning the minor's guardian may either sue or be sued on the minor's behalf, or the minor may be sued, may sue or be sued in his or her own name with the guardian's assistance. Okay? If a minor does not have a guardian, sorry, if a minor does not have a guardian, a curator ad litem is usually appointed to assist the minor. And if we look at Vista University, Bloemfontein campus, versus the Student Representative Council of Vista University, okay, here the High Court relied on its power as upper guardian of all minor children and assisted the minors in particular litigation. Okay, and then in some civil cases, a minor may litigate without assistance. For example, if the High Court grants the minor veniae agendi, okay, that is basically the permission to conduct litigation. Okay, it means in such a situation, the minor is treated like a major for purposes of the particular legal proceeding. Okay, other exceptions relate to maintenance claims against the minor in maintenance court. Okay, so an application to court for consent to marry without the consent of the minor's guardian, and in criminal proceedings, a guardian's assistance is not required. So, if a minor is an accused person in criminal proceedings, um, the minor is not, sorry, a guardian's consent is not required, or a guardian's assistance is not required. Okay. Okay. Very, very importantly, if the court grants a cost order against the minor, it is normally the minor who is liable, and in exceptional instances, the court may order the minor's guardian to pay the cost, either alone or jointly and severally with the minor. Okay, let's look at the capacity to incur delictual and criminal liability. Okay, so to incur delictual or criminal liability, the minor must be accountable. Okay, and very, very importantly, a person is accountable only if he or she has the mental ability to distinguish between right and wrong, and to act in accordance with that appreciation. Okay, and we know in terms of delictual liability, at common law, it is rebuttably presumed that minors between the ages of 7 and puberty are not accountable for their delicts. Okay, so very, very importantly, also, if the minor's guardian uses the minor as his or her agent or instrument, or negligently fails to prevent the minor from causing damage, the guardian may be held personally liable for the damages caused by the minor. Also, if the guardian employs the minor, he or she can also incur vicarious liability for the delicts the minor commits in the course and scope of employment. When it comes to criminal liability, a minor's capacity to be held criminally accountable is governed by the Child Justice Act. Okay, and in terms of the Child Justice Act, criminal accountability is under the age of 10 years old. That has now been extended to 12 years old. Okay, so a minor under the age of 12 years old does not have criminal capacity. Okay, I want you to to um, to read that. Okay, so students, um, I'm about to to wrap up, we will then, I'm going to record this now as concluded, and then I want to start with revision on Saturday morning. So, um, those of you residing in the Pretoria, Johannesburg area, I'm going to be in on that side of the world next week. I'm going to be having my two classes, the Monday and the Tuesday class from there. You are still able to provide me with query sheets to request one-on-one sessions or to submit written work to me. But please be mindful in terms of my work program next week. For all the other things, I'm available from Friday the 13th of November only. So you can submit your request, you can submit your written work, but I will only give it attention on Friday the 13th of November, but I will be online for class on Monday at 5:30 as well as Tuesday at 5:30 as well. So students, before I conclude for today, are there any questions for me? Are there any questions? Many thanks for the book. Yeah. I will send whatever other textbooks
Hello,
versions I have. I will send it to you guys. Who's that
hello.
speaking?
It's LZ,
LZ.
advocate. How are you doing?
I'm good, LZ. What is your question?
I'm just a bit confused about the age. Here
Mm,
in my Heaton book,
mm,
on page 106, it
okay,
says, I
what
just
does
want to
it
get to
say?
this page.
Mm,
It says a minor's capacity to be held criminally accountable is governed by the Child Justice Act, okay? And
yes,
then it
yes,
says the minimum age for criminal accountability is 10 years. You
yes.
mentioned something about 12 years.
It's been
It just
amended.
mentions here.
It's been
Okay,
amended.
so
Okay,
are
so
we going to penalized in the exams if this comes up and we say 10?
yes, you need to know the proper age. Okay.
Okay.
Um, what what I will do is, in terms of my understanding, I'm under the impression it's been
Mm,
amended to 12 years old. What I will do for you,
mm,
LZ, is I will confirm that and give you
yes.
clarity in Saturday's class. Okay?
Thank you so much. That would be
Okay, LZ.
appreciated. Thank you,
Okay.
advocate.
Best of luck for the week to you.
Okay.
Okay, students, if there's nothing else, then we will chat on Monday. Have a good day studying. You shouldn't be going out. You shouldn't be doing anything. You should just be sitting with your books. I'm the one who should be going out. So have a good weekend, study well, and we will speak to each other on Monday. Okay, students, goodbye. Um, Adele, we will speak to each other via email or I will phone you. Thank you so much, students.